Good afternoon, everybody. Thank you for joining the NASW New York Cares Community Engagement Initiative for the second event of the Spring 2026 Senior Series, Guardianships in New York, Key Differences and Practical Considerations with Sarah Myers, Esquire. My name is Angelique Imani Rodriguez, and I'm the Manager of Membership Engagement and Special Programs with NASW New York. I'm so happy to see you all here today. We appreciate your attendance and continued support of chapter programming. Registration for the upcoming first annual NASW New York CE conference, where you can earn up to 7.5 CE contact hours, is still open for registration. There's non-CE student sessions if you'd like to join us but don't need the CE contact hours. A hybrid format conference, you can join either in person or online. You don't want to miss out. Registration does close on May 15th. We also have a robust calendar of CARES programming over the next few weeks, including the last two events of the Spring 2026 Senior Series. In May, we have two joint town halls with 1199 SEIU on pay equity and an incredible immigration series hosted by the NASW New York Immigration and Global Social Work Collective. Additionally, we're accepting submissions for the Spring-Summer 2026 issue of the NASW New York Currents newsletter until May 6th. This issue's theme matches that of our conference. One New York, one voice, reimagining social work for a just future. We hope to see some submissions from you. Yes, you. Post-event, you'll receive an email that will share all of this information about what's upcoming at the chapter, as well as any resources or information provided by today's guest. If you're currently waiting on materials from recent events, they'll be out ASAP, and I personally thank you all for your patience. Please remember that by registering for any NASW New York events, you agree to abide by the NASW New York anti-harassment policy, the link of which I will drop in the chat for you all shortly. Once again, thank you all for joining us today. If you have any questions about this event or any other NASW New York Cares community engagement events, I will drop my email in the chat for you shortly as well. Without further ado, let me introduce you to our host for today, Sarah Myers, Esquire. Sarah, whenever you're ready, please feel free to unmute and begin.
Thank you for that introduction. Thank you to the NASW New York Cares for having me back. I think we've been doing a lot of programming for the past couple of years. And today we're going to be talking about guardianships in New York. I know with the social workers here work with young adults, possibly young adults with intellectual or developmental disabilities, as well as possibly seniors with cognitive impairments as well. So I'm just going to go ahead and share my screen. There we go. So we're going to be talking about guardianships in New York State, both Article 81 guardianships, Article 81 under the New York Mental Hygiene Law, which covers most usually individuals with cognitive impairment, which are not related to an intellectual or developmental disability, which those fall under Article 17A of the SCPA, the Surrogate Court Procedure Act. If you have any questions, feel free to put them in the chat. So we're going to talk first about just guardianship in general and what is a guardianship. And what happens with the guardianship is when a person is unable to make medical or financial decisions for him or herself. They're not able to sign a power of attorney, a healthcare proxy. A court proceeding is brought to first determine they have a cognitive impairment leading to functional limitations in that they cannot make medical and or financial decisions for themselves. There's no power of attorney or health proxy, or those documents are inadequate or inappropriate, and it's seeking to have the court appoint a guardian for those individuals, for that individual to make medical decisions, personal decisions, financial decisions for them. So again, as we talked about in the introduction, New York State has two main guardianships for individuals with cognitive impairments. First is Article 17A under the Surrogate Court Procedure Act, which deals with individuals 18 or over with intellectual or developmental disabilities, and Article 81 under the Mental Hygiene Law for individuals who are older with cognitive and functional impairments. And we're going to go through each one. But first, it's important to step back for a second and just talk about if a guardian is appointed, What are those guardians' responsibilities? For example, for a guardian of the person, they're ensuring making medical decisions for that individual, consenting to medical treatment, ensuring that if care is needed, that there's appropriate placement in a facility, in a group home, or home care in the home. And again, to liaison with the medical providers as to medical decisions to be made. It is important to note in either type of guardianship, the 17A or Article 81, that a guardian cannot make end-of-life decisions without court approval. So end-of-life decisions cannot be made by a guardian of the person unless the court allows for it, in a subsequent application. A guardian of the property handles the financial affairs of the person found to be incapacitated, the person in need of a guardian, marshals the income, collects the Social Security income, the pension income, opens an account title to the guardianship where the funds are all retitled to, and files accountings with the court to demonstrate to the court that all the funds have come in, have been marshaled, and any funds going out are for the benefit and sole benefit of their ward for, again, that accountability purposes. In terms of an Article 17A guardianship, these are brought in the surrogate court wherein the individual resides. It allows the court to appoint a guardian for a person, as we said earlier, with intellectual or developmental disabilities. And it's usually brought around when that person with intellectual or developmental disabilities is 18 or about to turn 18. And the Article 17A started back in the 1960s, around mid-1960s, where individuals with developmental and intellectual disabilities, right, when you turn 18, your parents don't automatically have the legal authority to make financial and medical decisions for their children anymore. So, for example, when each of my kids turned 18, they had to give the pediatrician permission for me to continue to speak to the pediatrician. Without that permission, my daughter's doctors are not allowed to speak with me once they turn 18. But what happens when an individual with a developmental or intellectual disabilities turns 18, right? If they don't have the ability to make their own medical or financial decisions, they don't have the ability to say to the doctor, I want you communicating with my parent, my guardian, whomever, then a guardianship would be appropriate, right, in order for someone to make those decisions for them and to access information for them. And the theory behind it at first was in loco parentis, right? Because the parent can't do it anymore, giving that parent still that authority. But now if we look at Article 17As from the eyes of the 1960s to the eyes of the 2020s, as we're aware, individuals there with developmental disabilities, intellectual disabilities, there is a broad range, on a spectrum, and some individuals with developmental disabilities are more independent, have more cognitive abilities than others. But unfortunately, at this point in time, the statute has not evolved with understanding of intellectual and developmental disabilities. And we'll talk in a couple minutes about, who can bring the proceeding and what the court looks for. But its 17As are used for a person 18 or older who has an intellectual or developmental disability, and someone is seeking to be appointed their guardian to make medical and or financial decisions. And again, it's brought again for those individuals to deal with healthcare, living arrangements, education, deal finances. And again, also, it is interesting because there are many individuals with significant intellectual disabilities who are living in group homes. They don't have financial means other than, for example, SSI, where the group home can be made the representative payee. So the parent or significant adult in their life may bring a guardianship proceeding under 17A solely to make medical decisions, because at that time there are no financial decisions to be made. On the other hand, I've done quite a number of Article 17As where the parents or loved ones are seeking both guardianship of the person and property because there's a bank account titled to the name of that individual, with those funds needing to go into possibly into a supplemental needs trust. So the guardians need to have the authority to handle the financial management as well. Right. There's the guardian of the person to make medical decisions, the guardian of the property to make financial decisions. And again, if there are no funds in the name of the individual for whom the guardianship is seeking, more often than not, the court just appoints a guardian of the person to make those decisions of medical decisions and health decisions, and a guardian of the property only appointed if there is property, monies, bank accounts to be managed. Who can serve as the 17A guardian? A parent, a relative, another adult. You can have many times also a group home may petition for guardianship because again, the individual's living there, he or she might not have family. So the group home can petition for guardianship as well. You can have co-guardians or bifurcated guardians, one guardian of the person, one guardian of the property, or co of the person, co of the property. Especially in the context of a 17A guardianship, it is important to have standby guardians. And I'm seeing this a lot now, just in the evolution of our practice, where mom and dad brought the Article 17A guardianship 40 years ago or so. The individual's now in his 50s, 60s, or 60s, mid 60s. The parents are no longer alive, and now the siblings or the group home is saying, "Hi, we're the standby guardians. We now need to act because our parent has passed, our parent or whomever was the guardian." In terms of the process of a 17A guardianship, we file a petition in the surrogate's court in the county where the individual person resides. And I see we have people, when people said hello in the chat earlier, we have people throughout the state. So in the county where the individual resides is the county in which you bring the Article 17A proceeding. With the proceeding that you file a petition, right? Who's the petitioner? Who's the proposed guardian? What's the relationship between the proposed guardian and the alleged incapacitated and the person with the developmental intellectual disabilities? Where do they each reside? And then also forms that two doctors or medical providers to fill out as to the nature of the intellectual and or developmental disability, along with copies of all the pertinent cognitive testing that has been done, right, the school testing and whatnot. Once that package is filed, if for any individual for whom the guardianship is sought, if they're living in a group home or facility, more often than not, the court appoints mental hygiene legal service to represent that individual who's in the facility or group home. If the individual is at home, more often than not, the court will appoint a guardian ad litem, an attorney who's who's done this before, who has experience in this, to do an investigation for the court as to the allegations in the petition, the nature of the disability, and whether or not the appointment of a guardian is appropriate. And then the court holds a hearing after the guardian ad litem files a report with the court as to the guardianship, and will meet with the petitioners. If more often than not, the alleged incapacitated, the individual should be there as well. The court will speak with them and then determine whether or not they're going to appoint a guardian. So what are the key documents? There's the petition for guardianship, which also attached to it is an oath and designation for the proposed guardian to say, "I will act appropriately and in the best interest of my ward." The two doctors' reports, psychologist reports, any interested party. So if the intellectually disabled individual has siblings and the parents are the ones petitioning, the siblings sign a waiver and consent saying, "I have no objection to the guardianship and to the relief sought." So one of the interesting parts or characteristics of a 17A guardianship is it's not catered to the individual. It's the person, if the court finds the individual to have an intellectual or developmental disability, warranting the appointment of a guardian of his person and property, the person who's appointed the guardian has what are called plenary powers, makes all financial and or medical decisions for that individual. You cannot tailor it towards the needs of that individual. And we'll discuss a little bit of that tailoring when we talk about the Article 81s under the mental hygiene law. So for 17As, if the person requires the appointment of a guardian, the court appoints a guardian with the full powers of a guardian, which are statutory, which are housed in Article 17A of the Circuit Court Procedure Act, and you can't deviate from them. Any questions on, and feel free to unmute yourself or put a question in the chat. Any questions regarding Article 17A guardianships?
We have a question that came in from Kate. When you say guardian of person cannot make end-of-life decisions without court approval, is that only for life-sustaining care? For example, tube feeding, MAID, etc., or for decisions like hospice?
Can you repeat the question? I didn't fully understand it, and I didn't see it in the chat. So can you just repeat that question?
Sure. Kate says, when you say guardian of person cannot make end-of-life decisions without court approval, is that only for life-sustaining care, and this includes tube feeding, MAID, etc., or for decisions like hospice?
So hospice, my understanding is, what is end-of-life decision? What decisions can or cannot a guardian make vis-a-vis end of life? So for end-of-life decisions, you can agree to hospice care, right? Because that just means no more treatment. You cannot authorize, right, a DNR. You cannot authorize removal of a ventilator or state that a ventilator cannot be used. It's really to, if a person is in a vegetative or comatose state with no chance of recovery, that guardian cannot make the decision to pull the proverbial plug. The doctors would have to do everything possible to sustain life unless the guardian got an order from the court otherwise. Did that answer, Kate, did that answer your question?
Kate, you can feel free to unmute if you'd like to clarify.
I'll make sure you appropriately got to that.
Yes, thank you. I appreciate that. Thank you.
You're welcome. I just lost the PowerPoint. So I'm going to, from my screen, something just happened. So we are going to just fix it real quick. Did on your screens it also go smaller?
It went a little smaller, but it's still visible. We're on the screen that says, what is an Article 81 guardianship?
Yeah. Perfect. And I see now, I see there are other questions in the chat. Here we go. So then there's a follow-up. How long does it take to get the court to authorize the end of life? And you're not going to like this answer. It completely depends on which county that you are in. Someone wrote, that's terrible. I'm not sure what they mean by that. So I'm going to just leave that. But in terms of getting court authorization, it really depends on the county that you're in, how long that takes. Because remember, right, guardians have an obligation to their ward, and end-of-life decisions, especially in New York State, right? Even if I'm the healthcare proxy, I can't make end-of-life decisions for the principal, for the person, unless there is clear evidence as to his or her end-of-life wishes. So again, the courts want to make sure that it's appropriate care that's being provided and takes end-of-life decisions very seriously. So again, I'm surprised. So as many of you know, New York State recently passed aid in dying legislation. And I'm surprised. I was wondering if someone was going to ask me that follow-up question. Well, then what about aid in dying? Can a guardian authorize aid in dying? And the answer is no, because a patient, the patient has to be cognitively intact in order to request aid in dying. It cannot be done by a healthcare proxy. It cannot be done by a guardian. Any other questions before we talk a little bit about Article 81 guardianships?
None in the chat, but I believe Stephanie had her hand raised.
I just had the same question about how long it would take a court order. I hear that they can consent to hospice because we see that in the hospital where I work, but just in terms of knowing a little bit more about the court order and how long it would take in terms of, the guardian is doing everything to sustain life, but say the guardian feels differently, how long would that take? But you answered my question. And then it looks like somebody said something along the lines of, why can they agree to hospice if it's not aggressive care? But it sounds like you shared a little bit about that it's not removing care or.
Exactly. It's not removing care, but it's not continuing with care. There is a question here, though. What document will the court medical facility accept to remove life support? So in the petition to the court seeking seeking end of life, in the petition, you have to set forth the circumstances. I'm the guardian of so-and-so. I was appointed at this period of time. In the past 30 years, this is now what the new situation is. This is what the doctors have advised me. This is the, his diagnosis, the prognosis. It's, stage 4 pancreatic cancer. He's in a lot of pain. He's, in and out of lucidity, but really not lucid. Court, please authorize, here's a proposed order, please authorize end of life care. Normally the courts will have a quick hearing to then determine that and then issue an order allowing the guardian to make end of life decisions. Just there's here, that's interesting. Illinois rules for powers of attorney decision making are very different, right? That's Kate in the chat. And yes, each state has different rules in terms of powers of attorney, healthcare proxies, and medical decision making. Teresa has her hand up. Teresa, do you want to unmute?
Thank you, Sarah. This is so helpful. So if the individual has, if they have an advance directive, or if they have a living will, that's not documentation that the medical facility will accept?
So that's an excellent question, Teresa. The question is, well, what happens if this person has a living will? So I'm not sure then, right, in the context of a 17A, if
Right.
if the person had capacity to sign a living will.
Yep.
But remember, we also, in the context of guardianships, and we'll talk about 81 Article 81 in a couple of minutes, right? You can have a guardian, to make medical decisions, but also there being a living will. And then the court may say, when the guardianship is brought, that the guardian can follow the living will and doesn't need court approval for end of life care.
Okay.
But you still need a ruling as to that living will. And then also here, there was a question in the chat. If someone has an intellectual disability, their father is the caregiver, but there is no guardian, can he elect hospice? So if there's no guardian, there are many other considerations there. So in New York State, we have the Family Healthcare Decision-Making Act, where if a person doesn't have a healthcare proxy or a guardian of the person, and they're in a medical facility, the facility can look to the closest relative to make medical decisions. So I don't know if with this example that Soraya put in, if the person is in a medical facility or at home. But again, in terms of end of life care in New York, there has to be evidence as to what those individuals' wishes are. So I don't really want, I want to leave it at that because it can get sticky and thorny. And I don't want to go into, is he home? Is he in the community? Why is there no guardian?
Yeah.
Did you ever sign a healthcare proxy? And electing hospice is different than end of life, stopping a ventilator, not doing CPR. And then Teresa, though, asked a question, what about a MOLST? So a MOLST is a medical form, the medical orders on life-sustaining treatment. It is not a legal document. So if there's a guardian of the person, he or she, I don't believe, can sign a MOLST consenting to end-of-life care because you don't have the authority within the context of the guardianship to do that. But MOLST also talks about in terms of has other medical issues, not just end of life. Those can be addressed, but a guardian cannot make end of life decisions without prior court approval. These are, though, excellent questions, and I think it's a lot of food for thought. And it's clearly something that happens a lot in the context of the facilities many of you may work in, or the clients many of you are working with. I do want to switch gears a little bit to Article 81. Oops. If the MOLST is developed prior to Article 81, is it honored? I think it's an excellent question, and the answer is it depends. And I know you don't like that, but again, it depends. If in the pleadings in the guardianship petition, when it talks about is there a will, is there a power of attorney, is there a healthcare proxy, is there a living will, if there is a MOLST, that should be noted in the petition and attached as an exhibit. And then at the guardianship hearing, request that MOLST not be revoked and that the guardian be authorized to honor and use the MOLST form. So I think that's a good segue from the question on Article 81 to Article 81 guardianships. So an Article 81 guardianship was brought on in other than, and I should have said this earlier, with 17A guardianships which are under the Surrogate Court Procedure Act. Those proceedings are brought in the surrogate court in the county in which the individual resides. Article 81 guardianships are under the Mental Hygiene Law, Article 81, and brought in the Supreme Court in the county in which the individual resides. Unlike 17As, which are based on a diagnosis of intellectual disability, developmental disability, Article 81 guardianships are brought based on a functional limitation. So, for example, when you petition the court for guardianship, you do not attach to them medical records. Those because, again, if the alleged incapacitated person has not given up his or her right to privacy, those cannot be given because they didn't authorize their medical records to be provided. And again, the guardianship is not what is your diagnosis, but what are your functional limitations? What are you unable to be doing? 81s are also much less restrictive than 17As because right in the 17As, we talked about if you're found to have, to have the nature of your disability such that a guardian is appointed for you under 17A, it's a guardianship and the guardian has very broad powers. And they're no carve out. So they're no, you can't sort of tailor it to that individual. With a mental hygiene law Article 81 guardianship at the hearing and then in the judgment, you can cater the decision towards the individual. So for example, the court can appoint a guardian of the property and a guardian of the person, but the guardian of the person has to consult with their ward before making any medical decisions. Or the guardian of the person can't place an individual in a nursing home or any facility outside their home for long term without court approval. Or the individual can still open his or her mail or can still have a credit card or keep some funds to themselves. It encourages to be as least restrictive as possible. So when an article, when is a proceeding brought? So when we're talking in the context of the seniors, the individual had a massive stroke, is no longer cognitively intact, has Parkinson's, has dementia, is not oriented to person, place, and time, is unable to pay her bills, is unable to make his medical decisions. So it's brought on what their functional limitations, what they are unable to do. The person, the mail has been piling up. The person that, can no longer open the mail or understand the mail or understand how to pay a bill or do simple math to balance a checkbook. The person can't follow the directions of the doctor, is unable to figure out, taking his medication on a daily basis. So again, we see them a lot in 81s in the context of seniors or individuals younger than seniors when there's a cognitive impairment. And I want to just discuss, right, which is why when we do estate planning or when we talk about our clients who are seniors or younger, part of their estate planning, the importance of it really is to do a healthcare proxy, to sign a healthcare proxy, appointing someone to make medical decisions for you, signing a power of attorney to authorize someone to make financial decisions for you if you are unable to do so. And NASW and I have been doing programs together. I've been doing programs for NASW for a number of years now. We do one on the importance of estate planning. And if any of you had participated, then, as you know, I always talk about my daughters in the context of when each has turned 18, I have them sign a power of attorney and a healthcare proxy. So I believe everybody over the age of 18 should have a power of attorney and healthcare proxy. Many people don't, which is why I bring a lot of guardianship proceedings, because a person didn't know that document was so important, or just didn't want to sign a power of attorney healthcare proxy. Said, I have a number of clients who say, look, Sarah, I'm never going to be incapacitated. I'm going to be fine. I'm not giving up control. I'm not signing them. And then we also have those individuals who never signed a power of attorney and a healthcare proxy. We have those individuals where they signed a power of attorney and a healthcare proxy, but they signed the wrong forms. So, for example, they pulled out a form online. It was not an appropriate New York State form. It is not a valid form. So the agent appointed under that purported power of attorney can't act because it's not a legal document. Or they have a power of attorney, but the agent under the power of attorney has misappropriated funds. It's been, I'll pay dad's bill and I'll pay my bill. Or the power of attorney is inadequate in that it doesn't allow for gifting of assets and therefore isn't allowing for Medicaid planning. And you have one spouse in the community and one spouse in a nursing home or needs home care at home, and you don't have the ability to move funds from one partner, one spouse to the other in order to effectuate that Medicaid planning. So those are all the myriad of reasons why an Article 81 guardianship may be brought. And it could be tailored to what the needs are. And even I was on I had a consult before I hopped on to our seminar today, where mom had signed 3 powers of attorney and 3 healthcare proxies, one to each of her kids. So now you have dueling proxies who has legal authority. And most documents, when you sign one and then you sign another one, revokes the prior one. So which one is valid and which one is not? So this was a good question before we continue. Here, so the way to prevent needing guardianship is to complete a power of attorney and a healthcare proxy. In other words, what are the ways to prevent needing to pursue a guardianship in New York? So I think we mostly drafted that. For the most part, yes, if you have a valid power of attorney, a valid healthcare proxy, and that power of attorney meets all of your needs, and there's nobody acting, then the agent is not misappropriating your funds, it should obviate the need for a guardianship. With a caveat, though, and I think I've spoken about this here as well, is I've brought a number of guardianship proceedings, even when there's been a power of attorney, when the alleged incapacitated person has been scammed, doesn't know can't recognize that they've been scammed, has threatened to revoke the power of attorney because they want to be able to access the funds. And so then the power of attorney is inadequate. But again, for the most part, if there is a power of attorney and it's an appropriate power of attorney and meets the needs, we shouldn't have the need to bring a guardianship. Someone just put in, sorry, I'm confused. The POA ends when the person becomes incapacitated. No, I never said that. The power of attorney dies with the person. So upon a person's death, if they had a power of attorney and the agent was acting, the agent could no longer act. If I have a valid power of attorney that has not been revoked, then you shouldn't then have a need for a guardian. So maybe you want to unmute Paige, because I'm really not understanding what you're asking. So feel free to unmute.
Hi,
If
Sarah.
Hi.
I apologize. I've been working with I'm a licensed social worker in New York City, and I actually used to do legal guardianship with Vera Institute's spin-off project, the Guardianship Project. Um, but yeah, what I was trying to say is that rather the power of attorney ending, like no longer being effective, it's always been my understanding that that is the case once, if and when the person loses capacity. But you're saying differently? That that's not the case?
The point of a power of attorney and healthcare proxy are known as advanced directives. I'm signing them in advance of becoming incapacitated. So God forbid I'm incapacitated, there's someone with legal authority to handle my financial affairs. If a power of attorney ends when I've become incapacitated, how's the power of attorney? Who's then handling my financial affairs when I'm incapacitated?
Right. Yeah. I don't know. That's just what the information that I have access to is always said, that someone can only sign it if they have capacity, but it no longer is effective when the person loses capacity. So I'm not sure
I'm not sure.
why that's not clear.
Right, then again, for every individual who's becoming incapacitated, we would need a guardianship.
No, my understanding has been that the healthcare yes, the healthcare proxy in most forms are always encouraged. And then there's the whatchamacallit, the
Family Healthcare Decision-Making Act is
yes,
only
that as well.
if
Um,
there's no
mhm.
care proxy. But if there's a healthcare proxy, then there's no need to look to the Family Healthcare Decision-Making Act because you have a healthcare proxy. I think maybe what you're thinking, and then we're going to move on, is that with a guardianship, if a guardianship is brought, perhaps because the power of attorney is inadequate, it doesn't meet the needs, or the agent appointed thereunder is misappropriating funds, the court can revoke that power of attorney. Right, but just the way you were getting at is doesn't make sense, because I have a power of attorney. The reason I've signed a power of attorney is if I should, God forbid, become incapacitated, I'm appointing someone to make my financial decisions. What you have posed, Paige and I, is that I've become incapacitated, but now the power of attorney can't act. So again, that would mean that every person who became incapacitated would need a guardianship because their power of attorney couldn't act. So I don't believe that's the case, right? That's not the case. So
My understanding is that there were other things in place, or other options for individuals that would allow their caregivers or family members or whomever to handle those affairs on their behalf, like us, like for Social Security income and all that. You can have a rep payee, so like between the rep payee and the healthcare proxy and MOLSA and all that. It was just always my understanding, because like I just
so
looked it up online right now even, and it says that power of attorney becomes ineffective once the person is incapacitated. So I don't know why it says that.
when you
But I'm going to look into this some more. I appreciate the clarification.
and feel free to reach out to me, offline if you'd like. But for our audience today, I want you all to be very, very clear. If you have a power of attorney and you become incapacitated, that power of attorney is valid. You sign it, right? I have a power of attorney. I'm in my 50s. I'm fine. I pay all my own bills. 30 years from now, I'm in my 80s. I become incapacitated. That power of attorney is valid when I've become incapacitated. That's the point of having a power of attorney, right? That and a healthcare proxy are known as advanced directives. I'm signing them while I have capacity. So if there come a point where I don't have capacity, I have appointed an agent under my power of attorney, an agent under my healthcare proxy to make those decisions for me. Is everybody clear on that? Okay, so I have a power of attorney, I have a healthcare proxy, I've become incapacitated. The agents under a power of attorney can act. The agent under the healthcare proxy can act. But I think it's important clearly that we are having this conversation because there's clearly a lot of confusion around advanced gifts and when they come into play. When a power of attorney dies with the person. And then someone put in the chat, maybe you're thinking of a non-durable power of attorney. New York State only does. The valid New York State power of attorney is a general durable power of attorney. And we're going to leave that there as well. Because New York State only do durable powers of attorney. So we're talking about the Article 81 guardianships, and they're usually brought when a person doesn't have the capacity to sign a power of attorney in a healthcare proxy. They have functional limitations and medical decisions need to be made, financial decisions need to be made, and they haven't signed a power of attorney in a healthcare proxy, or their documents are inadequate. So we have, like with the 17A, a guardian of the person to make medical decisions, overseeing actually home care services, overseeing healthcare, living arrangements, visitation, placement at home or in a nursing home, and a guardian of the property to make financial decisions. And there could be the same person to be the guardian of the person and property. It could be two different people. You can have co-guardians as well. Who can serve as the guardian? A family member, a friend, the county in which the person resides. If there is nobody to be the guardian, the court can appoint a public guardian or an attorney from what's called the Part 36 list to be that guardian. More often than not, when a guardianship is brought by one individual and another individual is contesting the guardianship, so we have a contesting guardianship. Son brings the guardianship, daughter's contesting it, says he's done these terrible things, she's done these terrible things and the like, and they're both seeking to be appointed guardians. More often than not, in those contexts, the court will appoint an independent guardian. Neither the petitioner nor the co-petitioner, either an attorney from the Part 36 list or a public guardian. How do you commence a guardianship proceeding? You file an order to show cause and petition, and the petition alleges that, who's the alleged incapacitated person, what are his or her, functional limitations, who are they nominating to be the guardian, and it could be the petitioners themselves, and what powers are they looking for the guardian. So the order to show cause and petition are filed in the Supreme Court. Usually about 4 or 5 days later, the court will sign the order to show cause, which will note when the hearing is and when the alleged incapacitated person must be personally served the petition and all the other interested parties or interested persons to whom they need to be served the order to show cause as well. Depending on the county, some counties always appoint an attorney to represent the alleged incapacitated person. For example, Westchester County always appoints counsel to the alleged incapacitated person and only appoints a court evaluator when it appears to be a contested guardianship. Bronx County, for example, always appoints a court evaluator, and the court evaluator, after meeting the alleged incapacitated person, might recommend to the court that counsel for the AIP be appointed as well. So it's very county specific on whether or not there's counsel to the AIP, a court evaluator, or both. There is a hearing in which the alleged incapacitated person is required to appear unless their appearance is waived by counsel. There's testimony brought as to the petitioner testifies in court as to the allegations in the petition and why the alleged incapacitated person has functional limitations that's necessitating the appointment of a guardian and that person's eligibility to become the guardian. The court, more often than not, especially when it's a not contested guardianship, will make findings on the records as to the appointment on the record as the appointment of a guardian. Then the petitioner's counsel drafts a proposed judgment, basically summarizing what happened in court, the appointment of the guardian, the guardian's powers, which get filed with the court. When the court signs the judgment, then something called a commission is issued, which is the proof that that person has been appointed guardian with the powers that person has. We talked again, and we said this earlier when talking about 81s and Article 17A's, medical evidence is provided. In Article 81s, you cannot provide any medical records unless the privilege privacy is waived by the alleged incapacitated person, or the court authorizes release of medical records to a court evaluator. The determination is, and the testimony and evidence is as to the functional limitations of the alleged incapacitated person. So testimony as both, testifying and evidence as to the person's unable to pay bills, bills haven't been paid, the person is being scammed, doesn't understand they're being scammed, person's in a vegetative state, can't pay their bills, and the like. And again, to show those functional limitations, why that person is incapacitated and why their needs are not being met, thus necessitating the appointment of a guardian. Once the guardian is appointed and commissions are issued, there are many more reporting requirements for the guardian in an Article 81 as opposed to an Article 17A. Within 90 days of a commission being authorized, the guardian must file an initial report with the court, basically saying, hey, court, I'm the guardian. I took the guardianship class. If the court requires it, I obtained a bond. And then every year, and these are the assets I've marshaled. This is the income I've marshaled. This is what I've done thus far as guardian. And then every year, usually in May of the following year, so the guardian has to file an accounting. So for example, the guardian had assets in 2025. They do their 2025 accounting, which has to be filed with the court and something called a court examiner in May of 2026. And then again, once guardian, if more powers are needed, or for example, end of life is needed, or you want to sell your ward's house, your real property, you then have to file a new petition with the court requesting those powers as well. Any questions on the mental hygiene law Article 81 guardianship? While we're waiting to see if there are questions, normally if there are advanced directives, but they're inappropriate or inadequate, the court will revoke those advanced directives at the guardianship hearing, or say they're okay, they're revoked upon the issuance of the commission. So someone can act in between the time there's the hearing and the guardian can then act. Any questions regarding the Article 81 guardianships?
Nothing in the chat, but feel free to raise your hand and unmute if you have a question.
Right. We had a very active chat just a couple minutes ago, but I think it's quieted down.
Yeah.
So I want to just sort of summarize in terms of 81 versus 17A and what's the difference. So the SCPA articles up, we have it. Kristen, yes.
Sorry, I just have a question in terms of the, so I am the director of social work at a psychiatric hospital. And so we may have family members who are guardians. And when they're doing the report, they may ask us for stuff. And I guess if we're trying to understand what is our role in providing certain things, we just had a family member say, oh, I need a letter for the court for this. And we're like, okay, well, what should it be? And do you have anything official? Like, do guardians get something like that they could give? We don't want to just hand over something. We don't know who it's to, what it's supposed to say, or what it's for. What's the guardian's obligation and all of that in terms of filing that report and having that information, or what might be needed to be able to help them finish that report?
Right. So I'm going to answer that broadly.
Okay.
And I'll sort of answer I think the question is basically, what if an incapacitated person is in someone's facility or has a doctor, what can the doctor provide or not provide? So you said you're getting these questions now. So with an Article 81 guardianship, when filing your annual accountings, you are required, if the person, your ward is in a facility, to get a letter from the facility basically saying, hi, I'm such and such facility. Sarah Myers is my ward. She's been here for this this amount of time. And we have care meetings every quarter as required where the guardian attends. So I think that's probably what they're looking for. But it's normally because you're providing with the annual accounting. It's also then if you're guardian of the person, you do have to talk a little bit about the medical care that your ward has been receiving. And then if they're in a facility, letter on letterhead from the facility that the ward is there, how long he or she has been there, with a bit about the care plan.
We have some questions. Sorry about that.
It answered the question that was asked. I'm assuming it would just want to add to that because the individual is asking in terms of a psychiatric facility. A guardian, just in terms of guardianships, a guardian is not authorized, though we can make medical decisions, to authorize the use of psychotropic medications without prior court approval. So you can allow the use of cholesterol meds, diabetes meds, but if if their ward has a psychiatric condition and the psychiatrists are recommending the administration of psychotropic medications, the guardian needs court approval to authorize that. There is a question in the chat. What prompts the POA to become active? Is it a medical letter stating the patient lacks capacity, or is there something specific? Stephanie, I think that's an excellent question. So we'll use me as an example. I have a power of attorney, sits in my office. My husband's the agent they're appointed there under. Technically, he can take my power of attorney and bring it to a bank and sign my tax returns and handle all my financial obligations. Because if I have a valid power of attorney, I've signed it and the agent can sign it, the agent can start acting right away. So some people say, well, Sarah, I don't want the agent to act. Like, I have capacity. I don't want that happening. So I say a couple of things. First, make sure you're appointing as your agent someone that you trust. Second, the agent doesn't need to sign the power of attorney when you sign it. The agent only needs to sign it when it needs to be used. In our office, we will not release, if we're holding an original power of attorney, we will not release it to the agent unless either our client authorizes us in writing to release it to the agent, or the agent provides us a letter from our client's doctor stating our client no longer has capacity, and then we will release the document. So we have quite a number of check and balances. Is the POA recognized if the agent hasn't signed the document? So the agent can't use the power of attorney until the agent has signed it. So Teresa, if I have your power of attorney, you've appointed me and you've signed it, but I haven't, I can't use it because I haven't signed it yet. So if the agent wants to act under that power of attorney, he or she must sign as the agent. Right? Because I'm not just bringing your power of attorney to a bank. I'm bringing it because I want to act. Teresa, did that answer your question? I will assume.
Yeah. Hi. Yes, it did. I asked because I have all the advanced directives and everything lined up. However, my power attorney is my brother, and my brother is assigned as power attorney in writing, but he has not signed the document. So what you're telling me is that it's not valid. He can't.
I didn't say it's not valid. It's
okay.
A valid document, but the agent can't act until he or she signs it.
Okay.
Right? You've signed it. It's a valid document. But it can't be used because the agent hasn't signed it.
Okay. So if the individual becomes incapacitated, can the agent sign it after the individual is declared incapacitated?
Yes.
Okay, great. I just wanted to make sure that I understood the law correctly.
Then what is the difference between the agent and the POA? So the POA is the form. It's a power of attorney. The agent appointed thereunder is actually technically known as the attorney in fact. We shorthand it to I'm acting as the POA for someone. So for example, Deborah, if you have a power of attorney and I am the agent, if I'm using that power of attorney and I'm signing a check, I'm going to sign it Deborah by Sarah. I should sign it as attorney in fact, but many people shorthand it to Deborah by Sarah as POA. So the agent is the agent under a power of attorney. So again, there's POA, it's a long thing to write out, so people write POA. But in theory, I'm the attorney in fact. But many people sign it, Sarah, as POA. So I want to just, if we have no other questions, I just want to make sure that we know the key difference between 81 and 17A, where Article 81 is the mental hygiene law brought in the Supreme Court for individuals with functional limitations where they cannot handle their finances or their medical decisions. 17A is under the Surrogate Court Procedure Act and brought in the context of individuals 18 years or older who have intellectual or developmental disabilities. I just like this. Why does guardianship matter? It's a legal framework for individuals who can't sign and can't understand a power of attorney and a healthcare proxy, or for someone who has them, but those are inadequate, to make sure then you have somebody to make financial and medical decisions for someone. So if the POA is signed by the POA, they can act at any time. So yes, I have a power of attorney. My husband is the agent appointed. I've signed it. He signed it. He can go and use it. That's correct. A lot of times that's done in the context of real estate, right? I'm selling my house. I don't want to go to the closing. I can give my attorney, my attorney a POA for the limited purposes of handling the closing, handling the real estate transaction. But yes, in the bigger picture context, like we'll end it the way we started it. My daughters each have a power of attorney, which sits in my office, or it's in one of my files. But again, if need be, let's say, and I had this once, one of my kids was traveling abroad. We needed to sign a tax return. I signed it as the POA. So again, you never know, or I had to pay some bills. I took out her checkbook. I signed it as the POA. But so again, once you sign that power of attorney and the agent has signed it as well, it's a valid, active document that can be used. I know our time is drawing to a close. So I just want to thank all of you for coming. I think we've had a very robust conversation. I think this is clearly something we should probably touch on again in our next series. I'm assuming someone here is going to be reaching out to me at some point. I didn't want to point to anyone by name, but I just want to thank the National Association of Social Workers, the New York chapter, which is an incredibly vibrant, active chapter, for inviting me back again. And I hope this program was helpful in terms of at least the tip of the iceberg for guardianships, and really, again, touching on a little bit about the importance of power of attorney and healthcare proxy. And I'm just going to say all of you should have your planning done as well, and should have a power of attorney, and should have a healthcare proxy too.
Thank you so much, Sarah. I appreciate you for being here. We've worked on a number of senior series together. If you are new to the NASW New York Senior Series, we offer it twice a year, once in the spring and once in the fall. You'll probably see Sarah again at that point. Sarah, we did have some questions around slides and information. Just to clarify, whatever has been approved to share with attendees will be sent over to you in a post-event email, including the recording of the event. I want to thank everyone very, very much for being here. We appreciate you all. Thank you, Yulia, for being our live captioner for today as well. Sarah, as always, you're incredible. Thank you for the information. Thank you, everyone. Have a great, great day.